Good morning, Richfield High School. My name is Stacy Thine Collins, and I am proud to be principal at Richfield High School Community, and I want to welcome all of you to the Minnesota Supreme Court Traveling Oral Arguments Program. It is with gratitude that I thank the court for selecting Richfield High School as a host site, and I want to welcome students to this amazing learning opportunity, our invited guests, and members of the court. Thank you for being here. It is now my distinct pleasure to introduce you to our MC, Chief Judge Todrick Barnett. Judge Barnett is a graduate of George Washington University, and he received his law degree from the University of Minnesota School of Law. Prior to his appointment to the district court bench in 2006, he served as senior attorney in the office of the Hennepin County Attorney and as attorney and senior attorney in the office of Hennepin County Public Defender. He has been a chief judge in the criminal presiding judge since 2016. Please welcome to the stage Chief Judge Barnett.
Good morning. Well, it's great to be here. You guys make me feel like a rock star. So I want to welcome all the students here at Richfield High School. I want to welcome the faculty, special guests, and the court staff who've joined us in this auditorium this morning. A special welcome to those of you in the classrooms and members of the community who are watching these proceedings via live stream. This is a very special opportunity for you to view firsthand the highest court of the judicial branch of the state of Minnesota. As you may recall from your social studies classes, the judicial branch is one of three branches of government. The other two are the legislative branch and the executive branch. Many of you have been studying the court system and have had a chance to talk to attorneys who recently visited with you. Our Minnesota court system is divided into three levels. You have the district court or trial court. That's where I preside, and that's where most of the cases begin. We have criminal cases, civil cases, family cases, juvenile cases, and probate cases. There are 296 judges in Minnesota at the trial court level. At the Court of Appeals level, where cases that are heard from the district court and appealed to the appellate court, there are only 19 judges there. And today, you'll see the Supreme Court, the highest court, the highest level, and there's 7 justices that will be before you today. So how did this case get here today to the Supreme Court? The case originated in Hennepin County in 2015. The issues arising out of this case have been reviewed by the Court of Appeals twice and by the Supreme Court once. In 2022, the plaintiffs again petitioned the Supreme Court for review, and the Supreme Court granted review, which brings us to oral arguments that you're here today. The case that you're going to see today is Alejandro Guzman, the appellant versus the state of Minnesota and Higher Ground Academy. You heard the lawyers correct me. That's one of the few times they get to correct a judge. So they're very proud of that. The appellants commenced this class action on behalf of children enrolled in the Minneapolis and St. Paul public schools. According to the appellants, their claims all arise from racial and socioeconomic segregation in Minneapolis and St. Paul public schools, for which they allege the state is responsible. The defendants are the respondents, the state of Minnesota, the Minnesota Senate, the Minnesota House of Representatives, the Minnesota Department of Education, and the Commissioner of Education. 3 charter schools in Minneapolis and St. Paul, as well as parents of some of the students attending those charter schools, intervene as defendants, or you might hear respondents. There are rules of decorum that are held in our courthouses, and this auditorium will be treated as a courthouse. So the case that you see is real. It's a very important matter that will be decided by the Supreme Court. So it's critical that the justices and the attorneys are not distracted. So we ask that you follow those rules, and we also ask that you turn off your cell phones. If there's any distraction, you'll be asked to leave the auditorium. Keep in mind that the total time of oral arguments is about an hour. It's now to convene court in the Richfield High School Auditorium.
Good morning, please be seated. We have one case for argument this morning, Cruz Guzman versus the state of Minnesota. A council will give each of you 3 minutes of time uninterrupted at the beginning of your argument, and then at the 3-minute mark, I'll interrupt you and see if members of the court have questions. It looks like the appellants have reserved 10 minutes for rebuttal. All right, Mr. Landon, you may proceed when you're ready.
Good morning, Chief Justice. May it please the court. The issue before the court today is whether and under what circumstances de facto segregation can violate the Education Clause of the Minnesota Constitution. Plaintiffs have alleged that by permitting and failing to remedy racial and socioeconomic segregation in Minneapolis and St. Paul schools, respondents have violated the Education Clause by failing to provide a system that is general, uniform, thorough, and efficient, and enable students to receive the adequate education to which they have a fundamental right. Plaintiffs, both the district court and the Court of Appeals below, ruled that plaintiffs cannot establish such a violation unless they prove intentional de jure segregation. Plaintiffs asked this court to reverse these decisions and remand for further proceedings, with the rule that a violation of the Education Clause does not require proof of the state's intentional creation of segregated schools. Respondents, in fact, agree with us on this point that the Education Clause does not require proof of intentionally segregated schools. Where we differ is whether plaintiffs must prove that segregation itself has caused students to receive an inadequate education, or whether de facto segregation standing alone violates the Education Clause. We see 3 possible outcomes if this court reverses the decisions below, each of which we believe would be consistent with the Education Clause unique mandate on the legislature, which has no counterpart in the US Constitution. The first outcome would be where there is evidence that shows de facto segregation exists in a school or district. This is sufficient to prove that the legislature has violated its mandate under the Education Clause. This is the per se theory that plaintiffs believe is supported by the affirmative mandate in the Education Clause, but not the only theory under which we would prevail. Outcome 2, where the evidence shows that a school district is de facto segregated by race or socioeconomic status, and also that students are not receiving an adequate education. Those 2 factors are sufficient to establish a violation of the Education Clause. Finally, outcome 3, this court can find that where there is evidence of de facto segregation and failure to provide an adequate education, and this evidence shows that de facto segregation has contributed to the inadequate education, this is sufficient to establish a violation of the Education Clause. As the Cerisi amicus brief noted, there is no doubt that racial imbalance in many Twin Cities schools plays a role in the dismal state of affairs present in this case. Plaintiffs will, of course, try the case under the rules set by this court, but the district court needs guidance on the question of causation, which it viewed only in terms of whether there is a causal link between racial imbalance and specific actions of the state. Because of this, even the third outcome is precluded under the lower court's ruling.
Counsel, I'm just going to stop you at the end of yours. Court have questions.
I just want to clarify, are you saying that as a matter of law, a school that serves predominantly or even entirely students of color is inherently inadequate without regard to school performance?
Yes, we do believe that when even de facto segregation exists, that is a per se violation of the Education Clause without reference to specific performance. And if you look back to the Sauk Center case over 150 years ago, this court made clear that the purpose of the Education Clause is to help students discharge intelligently their duties as citizens of the Republic. We believe that in a multiracial, multicultural society, a system cannot do that if it tolerates and fails to remedy racial isolation that persists in two of the largest school districts in the state. The New Jersey.
Could I just ask
Yes.
you though, what do you say to the people who have submitted Friends of Court briefs that say that using race as a proxy to measure educational adequacy, and to conclude, they say implicitly at least, that a school that is not white enough violates the Constitution because it sends a harmful message that one group is intrinsically better than the other?
Well, I would disagree that we are not alleging that race is a proxy for educational adequacy. What we are arguing is that permitting racial isolation is contrary to the mandate in the Education Clause. Again, going back to what this court said in Sauk Center about teaching students how to learn to be good citizens. The New Jersey Supreme Court addressed this idea of citizenship and the impacts of segregation on citizenship.
Can I ask you, so is adequacy, is that based in the first phrase of the Education Clause? Or is it related to the general, uniform, thorough, and efficient? I mean, is adequacy a separate thing from just general, uniform because of that first clause in the Education Clause about preparing students to be good citizens?
I believe that it's.
Are they independent?
I don't know that it can be separated out, Your Honor. The decision in Cruz Guzman 1 confirmed that the requirements in the Education Clause, which include both good, uniform, thorough, and efficient, that there is a qualitative component to assessing whether that has been met. And so adequacy is read into that requirement. I'm not sure that you can read it into one sentence standing alone in the provision. I'm not sure that this court's previous ruling said that.
Counsel, did the district court err in certifying the questions sua sponte? And then following that, the Court of Appeals err by answering that question? I mean, really, are you here too prematurely? Shouldn't this case have been tried?
I don't think that the district court erred by certifying a question. I mean, we think that the district court was incorrect to impose an intent requirement on an Education Clause claim, but the district court acknowledged that this was a question that was important and doubtful, and there is not a lot of precedent in this state that guides the court's decision. Quite simply, the court recognized that it needs more guidance from this court to be able to understand how to evaluate the type of allegation that we're making in this case.
But isn't the question simply whether students have the right to an adequate education, period? Forget the intent, the unintent, forget all of that. Isn't the question really that simple? And then the rest of it is about remedy?
Well, yes, I agree that the question before the court is about whether the students are receiving an adequate education. But what the district court ruled—
Not whether they are receiving an adequate education, as whether they're entitled to an adequate education, which it seems to me that question was already known. So that's why I'm asking you, if it seems like there should have just been a trial that occurred a few years ago And because it seems to me that you're all arguing about remedy more than anything else.
Well, we agree that the court shouldn't be arguing about remedy. We agree that that's not what's before the district court. We think that that was part of what was wrong with the district court's analysis. I mean, as to why there hasn't been a trial, the case, took the parties tried to resolve this case through years of mediation. I mean, that's why we haven't had a trial yet.
Is it accurate that none of the parties asked for this certification of this question, that the district court did it on its own?
That is correct. I mean, I'm not sure that we wouldn't have asked for a certified question once we received the court's ruling, because we think that the court's ruling is erroneous as a matter of law and impairs our ability to prove our case at trial.
Counsel, I want to ask you about parents' choice. If we adopt your rule of law, what role, if any, is left for a parent's choice about where to send their child for school?
Well, I think that that's up to the legislature in crafting the remedy. I don't think that's for the court to decide. I certainly think that
So the legislature gets to decide how much relevance there is to a parent's choice about where to send her child to school.
Yes, but the legislature should be free to weigh that against other countervailing governmental interests. And I don't think that there's any reason why that should trump other interests that the state has in preventing segregation.
What language in the Constitution, it is the duty of the legislature to establish a general and uniform system of public schools. In that phrase, what language in the Constitution supports your contention about segregation, that segregation by itself is a violation of the Constitution?
Well, we would agree that the word segregation itself is not in the Constitution, but we don't think that that limits this court's ability to interpret the meaning of that statement. This was something that was discussed the first time this case was before this court. There was the argument that the word adequacy was not in the Constitution, and the state believed that therefore there was no adequacy requirement. This court disagreed.
So your segregation argument fits under adequacy? I'm just trying to figure out what the hook is into the constitutional duty.
Sure. In addressing this question about the language of the Constitution in Cruz Guzman 1, the court said that an education that does not equip Minnesotans to discharge their duties as citizens intelligently cannot fulfill the legislature's duty to provide an adequate education under the Education Clause. That is the court's interpretation of the language in the Education Clause.
And so you think that means segregation?
We think that that does apply to segregation. And I think that there's been a lot of argument in this case about the meaning of footnote 6 in that opinion. I think that everybody agrees that at a minimum, what the court said in footnote 6 is that a system of schools that is de jure segregated is not general, uniform, thorough, and efficient.
When you say de jure segregated, just tell us what you mean in real words. Not Latin phrases, but
imposed with the intent of the state's intent to impose racial discrimination on the students. So it is clear that everyone seems to agree that in the de jure context, de jure segregation violates the Education Clause, even though there is nothing in the Education Clause that mentions de jure segregation. With that acknowledgement, we do not see any principle in distinguishing between de facto segregation and de jure segregation under the Education Clause. We don't believe that there is a basis to do so.
But counsel, what do you say to the amici, or the interveners here, the charter schools, who say, segregation is, there are different kinds of segregation, that you need to kind of slice that onion a little bit. There's de jure segregation, intentional segregation caused by the state, where, back at the time of Brown, there were actual laws that prohibited Black children from going to school with white children. That's state-imposed de jure segregation. And they say that's different than what charter schools do, because going back to the chief's point, the charter schools are made up of children whose parents have chosen that segregation, if you will, who have chosen to put their children there because they think their children will receive a better education, a culturally affirming education, and that those are different things, and that you're conflating those. And so my question to you is, should we be separating that out in some way?
Your Honor, I think that it's important to keep in mind that our allegations are based on the state's failure to uphold its duty under the Education Clause. There was a comment in one of the amicus briefs, I believe it was the Cerisi brief, that suggested that we are essentially saying that these parents are violating the Constitution by choosing these schools. That's not what our allegation is. That's a mischaracterization of what's at
But
issue in
isn't
this
that the
case.
practical effect if we adopt your rule?
No, we are not alleging that any action by parents is the violation here. What we are saying, and I, the amici and the interveners want to point out that there are some schools that excel despite racial imbalance at the schools, but they acknowledge that that's the exception rather than the rule for charter schools. What we believe is that a system that permits, now the students in Minneapolis and St. Paul public schools, they didn't choose to keep their kids in failing schools. They didn't choose to keep the kids in schools that were segregated by race. And to say that the state can't remedy that because of other parents who choose to escape those failing schools and send their children to a charter school that meets their desires, we don't think that that's an effective rule. We don't think that that should prevent the state from correcting the harm to the students throughout the system as a whole.
What is your rule of law? What would your, so for instance, Richfield High School is about 75% students of color. What would your constitutional rule, which wouldn't just apply to Minneapolis and St. Paul, but would apply everywhere, would that make Richfield close to unconstitutional?
Your Honor, we're not asking this court to impose some constitutional mandate for racial quotas.
I'm not asking you, okay, explain what that means, because I don't understand this difference between, you want us just to say Minneapolis and St. Paul are unconstitutional, legislature fix it. Is that kind of the bottom line? There has to be a reason it's unconstitutional. So what is that reason? That's why I asked this question. Would Richfield also be, if they got to say 80% of students of color, would that be unconstitutional?
Yes, we think that
even though the district they have no other choice to go. I mean, there's no other high school to go to in the district.
Your Honor, the question of when a school or a district becomes thoroughly segregated or segregated beyond the point of constitutional adequacy, we think that that's a question that is properly left to the district court. We're not asking this court to issue a rule of law that sets a bright line for when that line is crossed. In our allegations, the hyper-segregation in Minneapolis and St. Paul schools is not in dispute. There's not a question of whether those schools are segregated. The question is whether the legislature has a duty to remedy it.
Counsel, under your theory, kind of picking up off of Justice Thiessen's question, what if we're not here in the metro area, we're in many of our outstate schools where the population is predominantly white and therefore the schools are predominantly, if not exclusively white? What happens to those schools under your theory if we were to adopt your position? Are they unconstitutional because they're all white?
No, that's not what we're saying at all. Again, the question of segregation is a question of fact that varies based on the demographics of the district and the region.
Why would that be?
Because the racial demographics change over time and they're different throughout the state. We are not saying that the Constitution.
But if your argument is that a school is unconstitutional per se because it's segregated, why would that not apply? Why does it matter what the makeup of the particular school district lines are?
Because the issue is one of racial isolation and separating schools, allowing a dual system of schools where the demographics of even abutting districts are vastly disproportionate and don't represent the communities.
What does the state do then about districts like those outstate districts? I mean, what do you envision the state doing or the legislature doing?
Well, I mean, again, I don't
I
think
know
it's
that's not-
it's not my place to say what the state should do or what it will do or what it needs to do. But again, our definition, how we define segregation, I think that is an issue that is appropriate, for the district court based on the facts presented to it.
Counsel,
are not-
the district court was clearly concerned that the logical outcome of appellant's position here would lead to conflict with federal law on setting specific percentages of particular minority groups in particular schools. What's your view on that, and how do we get around that problem to get you the relief you think you deserve?
Well, we think there are multiple problems with what the district court said. The first is that it's focused on the remedy rather than focused on whether a violation has occurred. And that's not the role for the district court. Second, we believe that the district court is clearly wrong, that a remedy is going to require some sort of overt racial balancing. We simply don't believe that that's true.
Well, and let me pursue that point a little bit, because I read your brief on that point, but it seems to me that the district court sort of jumped to the end of the page, and the end of the page is your remedy, or maybe not your remedy, but the analysis of the problem from your perspective requires you to slice and dice school populations by race. And doesn't that lead ultimately to a test that says either you match these percentages or you don't? And I think that's what the district court is concerned. Why is the district court wrong about that?
Well, I mean, in this case, there is one obvious example of why that's wrong. In this case, the plaintiffs in the Department of Education worked on a bill that we thought that would address this, that was not based on race at all. It was looking at student assignment based on socioeconomic factors, which is not contrary to any Supreme Court law. And we also explained in our briefs that Justice Kennedy's controlling opinion, and parents involved, made clear that communities are able to take a race-conscious approach to addressing de facto segregation. It is simply not the law that is something that cannot be considered. There is language from Justice Kennedy's opinion that I think touches on this, really astutely. It says the plurality opinion at least is open to the interpretation that the Constitution requires school districts to ignore the problem of de facto resegregation in schooling. I cannot endorse that conclusion. To the extent the plurality opinion suggests that the Constitution mandates the state and local school authorities must accept the status quo of racial isolation in schools, it is, in my view, profoundly mistaken.
Was the settlement legislation, does that solve the constitutional problem? If that were to pass, would we not have a constitutional issue anymore in Minnesota?
We believe that would have corrected the.
So that's a remedy, that will at least
Yes,
give
that
us
is
a
an
guide for
example
what
of a remedy.
would look like.
Yes, but that's one of many examples of what a remedy could look like. Again, it's not the court's duty to narrowly cabin the legislature into.
Counsel, can I move you along a little bit? I understand you don't believe a causal showing is necessary, but if we conclude that one is, what do you think about requiring the class to show that segregation is a substantial factor in bringing about an inadequate education?
Yes, we think if that's what the court believes that we should prove, we're happy to go to the trial and make that showing of proof. We certainly think that that is a reasonable conclusion that the court could make, even though we don't think it's necessary.
Let me ask you one other question about the contours of what's before us. I don't see you as asking us to review the district court's decision that genuine issues of material fact exist about intentional segregation.
Correct. That is correct.
Counsel, the education clause focuses on the adequacy of the education system in the entire state of Minnesota. But this lawsuit seems to involve two school districts and how they've operated and conducted themselves. And the schools in outstate Minnesota, many of them, including the one in my former community, are in racially isolated school districts that have been identified by the Department of Education and supported by integration collaboratives and other ventures to try to address those issues. And so why is the statewide system in violation of the education clause simply because of how two metro area school districts have operated? I mean, in other words, following up with some of my colleagues, is the gloss that you're asking us to put on the education clause, does it really apply to the entire state of Minnesota? Or is this really limited to a more regional or local effect?
It does apply to the entire state, Your Honor, but the legislature has delegated responsibility to individual school districts, but the legislature is not able to abdicate its affirmative responsibility under the education clause by that delegation. It can't say, well, we did our job by creating the school districts, and the school district, if it fails a constitutional standard, then it's the school district's fault, and we have no obligation to fix it. We think that's profoundly wrong.
So a school district like Worthington that's 80% students of color, in your rule of law, would be considered a de facto segregated school, even if that school district reflects the demographics of the community that it sits in.
I do not know enough about the demographics of that district to answer that intelligently, Your Honor, I'll be honest. But I do believe that the remedy that the legislature puts together to address the violation we have identified in the Twin Cities is something that, yes, would apply statewide and be able to address racial isolation that is occurring elsewhere.
Counsel, could you articulate for me again why you believe causation is unnecessary?
Yes, it goes back to the issue of preparing students to discharge intelligently their duties as citizens of the Republic. What I began to identify earlier was comments from the New Jersey Supreme Court in the Booker case back in 1965. It talked about the impact of segregation on this issue of citizenship, and it acknowledged that children must learn to respect and live with one another in a multiracial and multicultural community. And the earlier they do so, the better.
You're really taking the spirit of Brown, even though Brown was a de jure case. Brown obviously said, point blank, segregation is a violation. There was under the Equal Protection Clause, but segregation is a violation of the law, primarily because of the pernicious effects that we know segregation has on children and on individuals. So that's where you're taking that from.
Yes, we believe that pernicious effect is equally present in de facto segregation. And again, New Jersey talked about this both in Booker and in the Jenkins case.
Counsel, your time has expired. We will
Thank
see Mr. Schulman on rebuttal. Ms. Kramer, as I understand it, respondents are dividing 16 minutes to the state and 9 minutes to the intervener. So we'll take the 3 minutes from you, Ms. Kramer.
Thank you.
And we'll give you the 3 minutes, I guess. I guess we're not taking it from you. We're giving it to you
Please don't
uninterrupted.
take it from me.
All right, you have 16 minutes.
May it please the court, my name is Liz Kramer. I'm our state solicitor general. I want to start by making clear two things that are not part of this appeal. The first is the equal protection claim. In their complaint, plaintiffs do assert a claim under the Equal Protection Clause of Minnesota's Constitution. And that makes sense. That's the kind of claim plaintiffs in the state usually bring when they're asserting that one group of Minnesotans is being treated differently by the government than another group of Minnesotans. But this appeal is not about plaintiffs' Equal Protection Clause claim because they didn't ask for partial summary judgment on that. It's only about their Education Clause claim. Yet in their arguments, plaintiffs seem to be asking this court to have the Education Clause do the work of the Equal Protection Clause. There's no precedent supporting that. The Education Clause does not become a one-stop constitutional shop just because the plaintiffs are school children. The second piece that is not involved in this appeal is adequacy. The district court and the Court of Appeals recognized that plaintiffs were not alleging that the Minneapolis and St. Paul public schools, or alleging, I'll say, in this partial summary judgment motion, that the Minneapolis and St. Paul schools were not providing an inadequate education as a qualitative measure. Instead, they were asking for summary judgment on the basis of demographic data alone. And demographic data about just 2 of Minnesota's 330 districts, representing less than 10% of students. So what is before this court? It's a narrow question. Whether the education clause of Minnesota's Constitution requires a particular demographic mix of students in each school. It does not. Appellants today and in their briefing have made no textual argument for that. The education clause says general and uniform and thorough and efficient. It has no words about racial balance or about demographics. And even if those words that are there are ambiguous, there's no evidence in the record of the drafters of our Constitution that they intended to impose any kind of demographic mix on the schools. So we ask this court to affirm the Court of Appeals and send this case back to the district court for a full development of the record.
Go ahead, Justice
Counsel,
Stewart.
I wanted to ask just a few questions again to kind of clarify what's before us. I understand that the state doesn't dispute that the education clause contains an adequacy requirement that requires a measure of qualitative assessment. Am I correct in that?
You're absolutely correct, Justice Chunich.
And I also read your footnote 4 that says you're looking forward if and when it goes back to the district court to propose a set of educational requirements to establish like a general and uniform system that provides students with the opportunity to receive an adequate education.
Correct, Your
I'm
Honor.
correct there?
Yes.
Okay. So then I want to know, it seems like the state was making a distinction between the opportunity to receive an adequate education versus whether students are in fact receiving that education. Did you mean to do that? Am I reading something in there that wasn't there? Tell me if that matters.
It sounds like some of the language might have been clumsy, and I apologize. What we are trying to draw a distinction between is the idea that test results alone can tell you how good an education students are receiving. So we can't just use some kind of output measure. We have to have a more holistic view of what opportunity our Minnesota school children are receiving and whether that opportunity is to an adequate education.
Now, let me ask you one more question. You talked about what the state should be responsible for, only the things that it has control over. When I look at our older cases in the Constitution, it seemed like the Constitution turned the whole thing over to the legislature because the drafters couldn't say what was an adequate education. And then we have cases saying that we have the clause saying that it's the legislature's duty to provide an adequate education. And then our cases say that the state can delegate that to local school districts in that, but the legislature maintains the ultimate control over those districts. So, sorry, that's a long buildup, but I want to know when you say you're only responsible for what you control, to me that seems like you control the school districts. So, the sort of statewide thing doesn't seem like that's a limitation on what the legislature needs to fix. And then you're thinking about maybe societal issues that the legislature may not have control over. So can you clarify that?
I will do my best. One thing we're trying to get at is this court's rulings, for example, in Skeen and in Klimek, where you made clear that the legislature's duty is to the statewide system. And so any failures, constitutional failures of the legislature necessarily have to be about the statewide system that is established. So that is one piece that we're trying to really call out. Our system of education like most states, does delegate a fair amount of control to local school boards, with the idea that local school boards have the closest relationship with the local communities and know what's best for the children in those communities. One for example, just
But Counsel,
from,
with respect to that, though, it seems like it feels like a little bit of a two-step, because as Justice Chudich indicated, the state, though, sets those policies and can tell school districts what they can and cannot do. So it does seem like sort of an abdication of the state's ultimate larger responsibility. Why am I wrong about that?
let me draw an example, if I may, from appellant's brief. Appellant's brief talked about like a natural disaster in one particular community and hypothesized, what if the school district, say a tornado takes down the only school in that community and the school district never rebuilds it? And appellant seemed to suggest that that would be the fault of the legislature. Well, it seems to me if the legislature is giving the per pupil funding to that district, and then it's the district that failed to use that to rebuild the school. So I do think there's some fair line drawing to be done between what really can be the responsibility of our legislature versus how it's carried out in the schools. But I also want to note that that really is not the question before this court today, because today what appellants are asking for is a bright line rule that any school that has either a 20% difference from the demographics of the district or is more than 80% children of color is automatically unconstitutional, regardless of whether that's the choice of parents or actually is the district demographics as a whole, as Justice Moore pointed out.
Is intentional discrimination, are you conceding that intentional discrimination is a violation of the Education Clause?
Justice
I mean,
Eason,
this goes to your point, I think, earlier about the difference between equal protection and the Education Clause, but it seems like there's some understanding that everybody's agreeing on that. I just want to ask you if that's true or not.
it is true, but I'm going to rephrase it a little. It's not about whether it's intentional discrimination, although of course it is. I'm talking about the kind of discrimination or segregation that was at issue in Brown versus Board of
So why does
Education.
that, okay, so say that kind of like
Dual system.
dual systems, is that because of the uniformity clause in education, or is it because of adequacy?
This court's footnote 6 in the earlier opinion called out all the words, all the 4 key words.
It didn't say adequacy, though.
It didn't say adequacy. I think it fits most naturally in the uniformity clause. If you are taking children of one race and sending them to one set of schools and children of another race to another set, that doesn't seem uniform.
And so if the argument here is about adequacy instead, well, I mean, I guess one question is, what's your understanding of what the hook is for de facto segregation? What is your understanding of that constitutional hook? Is that different than uniformity? Like, is adequacy different than uniformity? And, or why would intentional or not? I mean, that kind of Brown versus that Board of Education versus de facto education, this de facto segregation. Why does that matter constitutionally in terms of whether it, I mean, if intentional segregation is segregation, why isn't all segregation segregation?
Because we do need that constitutional hook. And none of these words, you know, whether it's the adequacy, which you all have interpreted as part of the Constitution, but falls necessarily from that opening clause about the intelligence of the people and the ability to participate in our civic life.
Okay, what about the pluralist argument? That seems to be the one that they're falling back on. That
What about what? I'm
the
sorry.
pluralist argument, to be a good citizen, you need to learn to live with people of all sorts. And so we need schools that look like that. That seems to be their kind of, I couldn't quite get that, but I think that seems to be their fundamental constitutional hook. Why does that interest not fall within that first clause of the constitutional provision in terms of adequacy?
If they're making an adequacy argument, again, that is different from what they have said in the courts below, and I don't think is fairly preserved before this court. But that's exactly what we are suggesting that we go back to district court and do. Prove that the education that the class members are receiving is inadequate as a matter of law.
They would say it's inadequate as a matter of law because it's not pluralist. I think that's what their argument is. So by definition, if you have a school that is sufficiently segregated in the kind of however we define that, that itself is inadequate because it's not achieving that pluralist kind of combining of people so they learned how to live with each other. I think that's their argument.
Page 12 of this court's previous opinion in this case made clear that adequacy has a qualitative component. And so if that's their argument, Justice Deason, which to date, it hasn't been clear to me whether that's true.
I agree with you on that, but yes, okay.
If that's their argument, then they need to show that qualitative component and make that link. Show us that the schools that they're calling hyper-segregated are the ones where children are not receiving an adequate opportunity for education.
Counsel, are you here too early? I mean, it seems to me that this needed a lot more work done at the district court level, because I still hear a lot about remedy and cause and causation and all that. So the same question that I asked opposing counsel, did the district court err in sua sponte certifying this question and then following up with the Court of Appeals, and now it's here?
Your Honor, no party has argued that. And now I'm thinking maybe we should have, because I absolutely think we're here too early. This affirmative partial summary judgment motion was brought 8 months before the end of fact discovery, before any expert reports had been exchanged. But I do empathize with the district court, who was hearing this pure question of law and felt like she didn't have a lot of guidance to decide it. And I think that's why no party has objected.
Empathizing with the district court is a good idea. Unless it's Judge Barnett, wherever he is.
I wanted to ask you about the causation standard. If we find that one's required, do you think that what I suggested to the opposing counsel is that the class needs to prove that segregation is a substantial factor in bringing about an inadequate education?
Justice Chudich, I think they need to start by showing that there is an inadequate education using qualitative measures. And it doesn't really matter under our education clause whether that's the result of segregation or other things. It just has to be, as we said in one of our footnotes, something within the redressability factor of standing, something that the legislature could do something about.
In the state's position, can segregation ever lead to a violation of the education clause?
Again, if it's that kind of dual system segregation. Short of that, only if the plaintiffs can prove a lack of this qualitative adequacy.
But counsel, why should they have to prove that when, it's almost as if we don't want to see what we see or know what we know. And there have been hundreds of studies done about the ill effects of segregation. Brown talks about that. Yes, it was a de jure case, but Brown is very clear that in talking about, well, the impact of segregation is greater when it is sanctioned by the state, but that segregation itself is a problem. It's because we don't have proximity with one another. We don't get to know one another. We don't get to become citizens of the world when we're in our own silos. And that in and of itself is a problem in our society and continues to be a problem in our society. So why isn't that enough? You can't have, I think is their position, you can't have the education that the education clause talks about when people are segregated. Why isn't that enough, given what we know and given what the studies tell us?
At least two responses, Justice Hudson. One is there's just no constitutional hook for it. And this court has been clear that when you're going to find a violation of our Minnesota Constitution, you have to start with the normal textual interpretation rules. They haven't argued that that's the plain meaning of any of those words, or that using your normal interpretive canons that they can draw it in. So that's the first thing. But the second piece is because it's missing from the text of our education clause, even though asterisk, there is the Equal Protection Clause claim still, which might be a better fit here. Because it is missing, making a rule like the one you just described is necessarily a matter of policy. And I'll note to you the multiple amici in this case with very different arguments about the meaning of voluntary segregation by families and schools and the benefits that might accrue from that.
Thank you, counsel. Your time has expired. Mr. Perry.
May it please the court. Jack Perry from the Taft Law Firm. Here with me is Nakima, and we're here on behalf of the intervenor charter schools, who are the prime example of what we're talking about, because they are, each one of them is roughly 97, 98, 99% Black or minority and on free and reduced lunch. They are what we're talking about here. And I'd like to start with Justice Thiessen's comment first about, does it apply to Richfield High School? And the test is not 80%, Justice Thiessen, it's 60% under the definition. There's four different definitions.
Yes.
So there's no question that this school is under the test, and it is a bright line test that this school is unconstitutional. Likewise, it's absolutely clear that all of our clients, our interveners, are, according to the answer of the plaintiff's counsel to Judge Johnson's question, we're all unconstitutional. And that is despite the fact that two of our schools, Friendship and Higher Ground, have been nationally acclaimed for beating the odds year after year after year. They don't fit the expectation and the presupposition in this case. The next question I want to respond to, or the comment you made, is Justice McKay, a couple different times you brought this issue of prematurity. And there's no question. I mean, even though I, in 2016, asked for the same certified questions and was denied, it is premature because we don't have expert reports, we don't have anything on causation. And it feels like causation, everyone recognizes there's got to be some causation. But in everyone's defense, particularly Judge Robiner, who has done yeoman's work in this whole deal, is Justice Anderson in 2018 in your dissent, one of the things, the phrase you really stuck out to us, because we were being tasked to do something, you called it a Herculean task. And when the opinion came out, we're like, okay, how do we do this? And we didn't object to the task, but when you look at the cases, we don't know what that means. And the ask of the interveners, assuming this goes back, is we need direction. Judge Johnson, in his opinion, begged for direction. Judge Robiner, maybe prematurely, but she was begging for direction. We have been begging for direction is because there's states like Pennsylvania just issued a 300 and some page opinion in February of this year based upon outputs, which is what I'm akin to. New York looked at it in 2021 and 2003, looked at inputs. This system, Justice Moore, you talked about systems, and that's what Skeen talked about, is a system. Well, that may or may not fit in inputs, outputs, I don't know. This court in 2018 talked about contributing factors, or the dissent called it causal related factors. I don't know how those fit. And we've tried for 8 years, and I will not fault plaintiff's counsel or the state or ourselves. Maybe myself, I could fault them, but we don't know where we're going. And I would hate to be back here 3 years from now, having tried an entire case on outputs. And the court says, we don't like that. And we look at the New York example. They had a 2003 case where they told the litigants, we're looking at inputs, right, wrong, or indifferent. And then when they tried the case again in 2021, they knew what the direction was.
I think I know what you mean when you mean say outputs and inputs, but can you be more specific?
Oh, I'm sorry.
On the inputs, what do you mean by that?
Okay, so the inputs, and you heard a little bit from Solicitor General Kramer, it's like the state can control what it does, the monies it's spent. Like the Skeen case is all about financial equality, and that's radically important, absolutely. But I'm a parent, and what I care about is not participation trophies. I want results from my kid.
The output.
And that's what Pennsylvania went through. But I don't know how many months the trial was, but the opinion is 300 and some pages, and it is thick. So outputs is very hard.
But counsel, what do you say to appellant's argument that, yeah, there's parental choice and maybe these two intervener charter schools are doing well, but it looks like, at least the data that I saw in the briefing, and I don't think there was much disagreement, they're kind of the exception, and that most charter schools are not doing much better than what the traditional public schools are doing. That's one point. And then secondarily, what about the parents of those kids who, for whatever reason, either can't go to the charter schools because of capacity limits or whatever it might be, or choose a different route? They choose to keep their kids in traditional public schools. Are they supposed to be satisfied then with the deplorable conditions and the outputs in those particular schools just because some other parents have chosen this route? What do we?
I'm going to ask it two different ways. One kind of a snippy legal way, and then I'll ask more of an honest response to it. But I think you already answered this question. In 2018, you said both the majority and the dissent agreed that you're being asked to do this Herculean task. We are not being asked, in order to get over the disability issues that the dissent was very concerned about, and as was the majority, was you're not allowing us and Judge Robiner to make determinations of educational policy. Absolutely clear, everyone agreed. And in this case, we have a 2013 with the AIM Act, which has two issues smacking each other. We have, in that one, it's about integration, but the exception, as found by the administrative law judge in 2016, recognized the legislature kept the exemption from charter schools from integration rules, because they are supposed to be the great experiment trying to figure out what works and what doesn't work, right, wrong, or indifferent. But under the 2018 decision, we can't get into this. As a more practical matter, is the charter school laws, despite the fact that they have the same outputs, they are a perfect thing for you to look at. Solicitor General Kramer talked about, well, if we go back, we'd like to identify what would be an adequate education, all this stuff. The state's done that. Since 1991, the state has done a terrific job with it. They created contracts. So every single one of the charter schools has to have a contract with the state and the authorizer. And the authorizer has to be an approved, it could be St. Thomas or Hamlin, whatever institution wants to get their, roll up their sleeves and work for solutions. They have contracts that have output goals, input goals, everything. They have defined that. The problem is that as it relates to charter schools, someone needs to enforce those. And Minnesotans don't like enforcing and saying, you're not doing your job.
Council, given the time, I want to
I'm
ask
sorry.
you to respond to the pluralistic argument that, that's a really important part of education, and how can that be done in schools that are almost all of one race or another?
The director, I asked the exact same question to the director of Higher Ground. It's almost all black, and he said, he goes, well, I'm from Ethiopia. And if the rule is that we can't educate people if we're all looking one way, or some whatever group you want to put, then our entire country couldn't succeed. So that's a false narrative, is that we need to teach the basic fundamentals of math, science, etc. And you can teach the socialization within the school regardless of who's sitting next to you. And he was just very, very pragmatic in that. I don't know if that is responsive to you, but it resonated with me that here's a person who's running a school that fits all the negative categories, and he absolutely believes, and they've studied it, and which is, if we get back to the prematurity, if we went forward, we would be able to show what happens to these kids along the way. Are they able to socialize the way that we would want them to, even though their schools are, quote, isolated?
Thank you, Council. Your time has expired. I know it went fast. Sorry.
Yeah, thank you.
Then we'll hear from Mr. Schulman for 10 minutes on rebuttal.
Thank you. May it please the court, Madam Chief Justice, I want to say I'm tempted to say we have to stop meeting like this. But first, what I really want to address here, there was an argument that adequacy is not involved in this case, or that adequacy somehow hasn't been determined by this court. In fact, the court crossed the bridge to adequacy and what it consists of and how it's defined long ago when you decided the Skeen case first, and then again in this case. And then the court not only said that, I remember that my colleague was asked, which words does adequacy fit? Well, the clause says that, and in fact, this court said in footnote 6, it is self-evident. Those are very strong words. It is self-evident that a segregated system of public schools is not general, uniform, thorough, or efficient. So, first of all, segregation applies to all 4 of those words in the Constitution. Second, that adequacy is in fact involved in this appeal, contrary to what the state respondent said, because there is, to say that we didn't present evidence of adequacy is not correct. There is extensive, undisputed evidence in the court record below of the achievement gap that has existed as shown by test scores of students of color compared to white students. And
So is there a threshold test score?
Excuse me?
Is there a threshold test score that shows that a school is adequate or not? Because there's 2 arguments it seems like. One is some groups are performing poorer on tests than other groups. And that sounds like an equal protection argument to me. Adequacy seems like it has to be the same for everybody. So why am I wrong about that, I suppose, is the first question.
Okay.
And the second question is can you define a particular test score threshold that would make a school inadequate or not?
Well, that's really a matter of evidence, and this court's not being asked to determine that.
Well, eventually someone's going to have to determine that if that's your
Right.
theory. So I'd like to understand it.
The district court will determine
Well, I'm
that
saying
when
we have
go.
to send a rule to the district court, so I'd like to understand it.
Okay. The rule, can I say there is a specific number? No, I can't say that. I won't say that. And I'm not asking this court to say that. But there's a percentage gap of like 50% between what students of color do on these achievement tests and what white students do. And that's important. This court has defined in its decisions what it constitutes an adequate education. And for example, it cites Pauly v. Kelly, quotes from it with approval in Skeen, cites it in this case. And one of the first two things Pauly v. Kelly says in listing like 9 elements of an adequate education, the first one is literacy. The second is the ability to do basic mathematics. And the tests themselves show that students of color are not able to do it.
So can I just ask, so it sounds, there's 2 things that I'm hearing now that we're talking about adequacy and test scores. One is, it suggests that it's not segregation by itself, but the fact that segregation leads to poor test scores. And so that seems like there actually has to be some kind of causal connection to adequacy. Or is it that every segregated school leads to these poor test scores, and so every segregated school is inadequate? That doesn't seem to be factually correct. And so that's where this is where my confusion is.
As my colleague said, there are 3 potential outcomes here. The first is, well, there are 4 if you say that we have to prove de jure segregation, or there's no violation of the education clause where there's segregated schools. The state agrees with us that that's not true, that shouldn't be the law. We don't have to prove it. Okay. So the first is what we call the per se theory. if there is segregation in a school, regardless of test scores or anything else, if there is de facto segregation, that leads to an inadequate education. That is inadequate in itself. The second is if de facto segregation exists and there is evidence, and in this record there is, that students are not performing and they're not getting an adequate education, then that in itself, those two factors alone.
But that would, the second part of that would be inadequate even without the segregation, right? If the tests, under your theory?
Well, that's arguable. I mean,
Okay, all right.
and the third is that if both of these exist, de facto segregation and inadequate education, and there is the plaintiffs must also make some showing of a causal connection between the segregation, the de facto segregation, and the inadequate education. And we are prepared to proceed on whichever of those lines this court directs us
But
to
your
proceed
theory is
on.
that you're arguing for the first one, though.
We're arguing any of the three.
You'd be okay with any of them.
That's right. We want to get back to the district court and prove our case.
Can you try and just say a little bit more about the distinction between 2 and 3? Because
Yes.
I'm having trouble finding why 2 doesn't require some causal.
Well, that's a possibility. That is something this court could say. If both exist together, then the court assumes that there is causation. And the third is, if both exist together, we have to show that the de facto segregation is causally related to the inadequate education. And, we're prepared to do that.
Is 2 more of a correlation then?
Right,
Okay, all right.
right.
Thank you.
Correlation without causation, or the necessity to prove causation. So, adequate, and for counsel to say that we didn't present evidence of adequacy in the district court is not accurate. And it's in the numbers are in the brief, but there are two facts that are not disputed in this record. One is the demographics.
So I'm a little uncertain about the theory now. I thought that when when your colleague, your co-counsel was here, when we were talking about where does segregation fit within the words of the education clause provision, I thought he was saying it fits because of adequacy. Segregation relates to whether the education is adequate. Maybe I misunderstood him, and if I did, I apologize, because I understand you to be making a different argument. You're saying segregation is over here, and adequacy has to do with performance of the students.
It's actually both. And again, I go back to footnote 6, and of course, this court is the one can tell us what it really meant. What I think really doesn't matter, but very strong words. It is self-evident that a segregated, and I'm quoting verbatim, it is self-evident that a segregated system of public schools is not general, uniform, thorough, or efficient. And of course, the education clause says that the legislature shall establish a general and uniform system of public schools, and by whatever means, taxation or otherwise, shall provide sufficient funding so that those schools are thorough and efficient. So the schools have to be general, uniform, thorough, and efficient. And
If we interpret it as broadly, footnote 6, you're right, we'll figure out what we meant. But if we interpret it as broadly as you suggested, doesn't that lead us into a collision with some of the federal jurisprudence about percentages of minority students and so forth? Question I asked your opposing counsel.
No, Your Honor, it does not. As you said in Cruz Guzman 1, the district court must answer a yes or no question. Is the education clause being violated? That's the yes or no question. If it finds that the education clause is being violated, then it goes to the legislature to provide a remedy. Now, and the legislature, well, we think that it is simply wrong. First, we think it is simply wrong to say federal law prohibits any consideration of race whatsoever. And we've talked about that in our brief.
Thank you, counsel. Your time has expired. Thanks to all counsel for the help you provided to the court in this matter. This case is submitted. We'll issue an opinion in due course. We're going to recess now briefly and then come back out and talk with the students. But I want to please ask the audience to join us in a round of applause to thank counsel for coming on the road with us. Thank you. I understand now, counsel, and the parties will exit the auditorium, and then the court will come back and talk with the students. We're in recess. All right.
Students and staff and any visitors that remain, if you could please be seated. Our justices are going to re-enter and we're going to proceed with the Q&A.
All right. Can you hear me? There we go. All right. Before we continue with the program, we just want to take a moment here and recognize some of our distinguished guests in attendance this morning. We have Richfield Mayor Gonzalez. We have the Richfield Public School Superintendent Steve Yanowski and members of the Richfield Executive Team. We have members of the Richfield Public School Board, members of Richfield Optimist Club, and also we'd like to thank the following people, especially the principal, Ms. Collins, who's just been so wonderful to all the judges here and staff. I'd like to especially thank Carla Vela, Julie Magnuson, Sarah Jesperson, also Andrea Manuel, Ben Powers, Miriam Burgert, also Andrea Gurink for providing technical support. Mike Davis, who coordinated all the volunteers, of course, the attorneys as well. And a special thanks to all of the students who helped the judges this morning. Our student hosts have been so wonderful in getting us around the school. Also, we'd like to thank like I said earlier, the attorneys as well, Richfield Police Department for providing security. Also, the Richfield School District for providing the live feed and recording. And finally, a thank you to all of you, the students who are here in the auditorium and those students in the classroom. This is a great opportunity for all of you now to ask some questions. The judges can't talk about the case that you just heard, although you might have a lot of questions, and they can't talk about court cases that are pending. But they can talk about their work experience, their life experience, those things they can talk with you about. If you go, why can't they talk about the case? Because it's unfair to the litigants for them to talk about the case when the decision hasn't come out. It would be unfair. So I know you might have lots of questions, and we ask that you come. There's 2 mics up here near the stage, and when you come up to the mic, we'll ask that you say your name and then ask the question, and that would greatly be appreciated. So now we're going to welcome back the justices of the Minnesota Supreme Court.
Hi, everybody. You've been great. Yeah, great audience. So what we're going to do is we're going to just briefly introduce ourselves to you, and then we're going to start taking your questions. I'm Lori Gilday. I'm the Chief Justice. I've been the Chief Justice since July of 2010. I've been on the court since January of 06, and I was an attorney for about almost 20 years before I became a judge. Justice Anderson.
Thanks. Thanks for the great welcome. My name is Barry Anderson. I am a graduate of Gustavus Adolphus College, University of Minnesota Law School, practiced in Fairmont and Hutchinson, Court of Appeals for 6 years, and I joined the Supreme Court in October of 2004.
Good afternoon. I'm Natalie Hudson, and I was on the Court of Appeals, which is the court below us, for about 13 years. And then I joined this court about 8 years ago. But when I was a practicing attorney, I did appellate law. I did what the attorneys you saw here today doing. I argued cases before the Court of Appeals and before the Supreme Court.
We do everything in order.
Hi, everybody. My name is Margaret Shutich. I've been on the Supreme Court now for 7 years. I was on the Court of Appeals for 4 years before that. I graduated from Anoka Senior High. I did some prosecution when I was in practice, and I also did some private practice.
Buenos días, mi nombre es Ann McKeag. Yo hablo poquito español porque mi esposo nació en Mazatlán, México. Yeah, okay. I know, the chief's looking at me like, show off. Bonjour, my name is Ann McKeag. I am from Federal Dam, Minnesota, which is up in Cass County. My hometown's 106 people. I went to college down here at St. Catherine University after finishing high school up north. And then I went to Hamlin University School of Law. I was on the district court for almost 9 years. I had the fortunate of working with Judge Barnett, who, despite my giving him a hard time, he's a lovely human being, and we're really glad that he's with us here today. And you can quote me on that. And then I moved to this court in 2016. I'm really happy to be here. So let me wait. Oh, that way.
I'm Paul Thiessen. I've been on the court since 2018. I was not a judge before I was on the court. I practiced law for a long time, and I was also in the Minnesota legislature representing Richfield and Minneapolis for about 16 years. And most importantly, my mom taught at this high school for about 20 years in the 80s and 90s. So.
Well, good morning, everybody. Great to be here. My name is Gordon Moore. I've been on the Supreme Court for almost 3 years. Prior to that, I was a 25-year resident of Worthington, Minnesota, where I was a private lawyer, county attorney, and then for 8.5 years, a district court judge in the 5th Judicial District. Before that, I worked at the Attorney General's office and grew up in Rochester. And based on what I saw last fall, you folks have an outstanding boys soccer team in this high school.
All right, well, that's us. We're really grateful to Richfield High School for hosting us today. So thanks to all the faculty and staff and the administration who have made us feel so welcome. And now we want to see if you guys have questions for us. Come up to the mic, please. And I'll go back and forth and call on you. Go ahead.
Bourgeois name or either Naya Briggs. My main question is, how do you get into law when something like this is very serious? Because a person like me, I'd like to get into law myself. My question is for the lady, Ms. Lady in Pink, gorgeous, by the way. So I'm just wondering, like, how do you guys get into this sort of thing?
So we answer questions in order. So it's not Justice Hudson's turn. But I will defer to Justice Hudson.
Thank you, Chief. So you want to be a lawyer? Yes. Well, you need to finish high school. Then you have to go to law school. Law school is usually about 3 years. There's some law schools that are a little bit longer if you're doing kind of part-time sort of work. But it requires dedication. It requires good analytical skills. It requires good writing skills, excellent writing skills. It requires the ability to dissect complex information. And to remember what you've read and to be able to apply what you've read to particular facts. So I think if you have those skills or you're willing to perfect those skills, you can do anything you want to do. If you want to be a lawyer, you can be a lawyer. So you need to finish high school first, work on the classes that make you write, work on the classes that make you do complex analytical thinking, work on your speaking skills as well. When you go to college, I think a liberal arts education is probably the best thing to do if you want to be a lawyer. So you don't have to major in pre-law per se, but again, courses that make you write and think critically. English, I was an English major in college. English, political science, sociology, history, those kinds of courses. So if you do that, you're well on your way.
Go ahead.
Thank you.
Hi, I'm Justin, and it's a great honor for you two guys to be here in our school. And we really appreciate it. And my question is, if the justices land on a decision that the public or media doesn't like. How do you deal with that?
So, interesting question, and it will almost certainly happen to you within 30 seconds or so of becoming a judge. You're gonna issue an opinion. There's gonna be criticism of it. Law professors may write articles about why you're wrong. It's part of the price of admission. My one observation about this is, having now been doing this for almost a quarter century, including my Court of Appeals time, I'm not troubled by criticism. It does kind of bother me when the criticism comes from people who clearly haven't read what we've written. So my advice to you, if you want to criticize something we've done or something some other court or some other judge has written, go right ahead, but at least read it before you criticize it.
Go ahead, next. Go ahead. Come on up.
Hi, my name's Tania, and I just want to say thank you for allowing me to have the time to actually have these conversations with you. I had a question about when you are actually going through a case and you are hearing both sides of an argument, and there's terminology that is going through that isn't directly being addressed by the Constitution, but they are still using constitutional clauses to present it in front of you. How do you make judgments on that when it isn't actually included within the Constitution itself? And how do you bridge the gap so that it isn't a matter of it not following constitutional law, but also where you can have conversation with that person to appease that law to actually close that gap?
So I think that's a great question. And of course, we're not going to talk about the case today, but we often will have cases where we're interpreting either a provision in the Minnesota Constitution or the United States Constitution. And so we read the words and we look to our precedent. Minnesota Supreme Court's been around a long time. We've written a lot of things about, we've written a lot of decisions about a lot of provisions. And so we look to those cases to see how have we interpreted this phrase or this statute or this constitutional provision before. We, of course, listen to the parties' arguments, and we spend a lot of time reading their briefs and reading the things that they cite in their briefs. And then the legislature gives us rules that help us interpret provisions. So they'll give us principles of statutory construction, let's say, for example. Those are just rules that guide us, that help us interpret provisions. So we look to all of those things, and then we rely on each other. The Minnesota Supreme Court really is one of the glories of the state of Minnesota, I would submit to all of you. We have amazing respect and admiration for each other, and we work really hard together. So all of those things go into the mix in deciding the questions that come before us. Thanks for your question. Next.
Thank you.
Hello, Justices. My name is Samantha. I do have a quick question. I don't know for sure if you're able to answer it, but you guys mentioned the word adequacy a lot during the case today, and I'm just wondering if you could define that. I had a couple of other students who were just a little bit confused about the definition.
Justice Chudich, do you want to?
I think that's a little too close, don't you? Yeah. I think that's a little too close to discussing the case.
Would you be able to just define the word? Is that possible?
I think I'd rather not.
Okay.
Given,
That's okay.
Given that it's so central to the case.
That's okay.
Okay, sorry about that.
You're all good.
Should I keep it?
Go ahead.
Next one.
Yep, step up. Go ahead.
Hello. First, I want to say thank you for coming again. It's a great honor. Thank you for the opportunity. My question is, do you have like a general philosophy that you approach cases with? Would you say more of like a tight constructionist, a loose constructionist? Can you be a loose constructionist when you're in the Minnesota Supreme Court?
Yeah, I don't really approach a case with a philosophy per se, but we all pay total attention if we're interpreting a statute or the Constitution to what the language is, and you start with that. And then, you look to the parties to give you a lot of help on what this question involves. But I don't, I try to make sure that we give parties, that we hear them respectfully and all of that. But I don't go by one of the philosophies that you might have heard, like originalism or that kind of thing.
Go ahead. Next question.
My name is Benjamin. I just want to thank you guys really quickly for listening to our questions.
Can you just go a little closer
okay,
to the microphone?
Sorry. I just want to thank you guys really quick for listening to our questions and answering them. Do you, or if you do, how do you take into account the evolving moral expectations of the younger generations in your rulings, and do you have any examples of this?
Well,
I wanted to try and be clear with my
No,
wording.
no, I think I understand what you're saying because certainly things have changed with the younger generation. You know, I always thought that I'm the youngest one on the court, by the way. Let me just say that. So I'm probably the closest to your philosophy. And I'm also a parent of 5 children. So I think that in our discussions, we certainly try to talk about the impact that it will have and the different ways that the community may view our decision. It's one of the great things that the chief mentioned about when you have 7 different people who come from 7 very different backgrounds, it makes the discussion really interesting and really rich because then we can all bring those different perspectives, including our life experience, which for many of us includes parenting. And so, yes, we do take that into account. Good question.
Hello and good morning, whatever the plural for your honor is. Honors or what? But so I had this on my mind since I've heard that the 7 of you were coming here. But what was the most outlandish case that you've covered spanning your entire career of law, which could span from you being a judge or perhaps even a lawyer yourself?
It's a really good question, and I hate these questions. So
I always love a good story.
That's an honest. Well, because I'm terrible at coming up with stories. I'm really not the best to answer this.
All right.
Of course, what's outlandish is in the eye of the beholder, right? I mean,
Right.
you might think it and I might not. But when I was in private practice, we had a 5-day jury trial about a magnolia tree.
Okay.
The tree survived.
All right.
Next question.
All right. Thank you.
Hi, my name is Thomas. Thank you for coming to Richfield High School. I just had a question about if you're in a court case and there's 2 sides and they're both making really great arguments and it's kind of like a gray area, how do you make your choice?
Yeah, well, I get a second chance to answer a question now, thankfully. That's a great question. And I think the answer to me is kind of in the name of our job. You know, we're judges, right? So we kind of talked about all the rules we look at. You know, we look at the statutes and the parties' arguments and our old, prior cases, that kind of stuff. But at the end of the day, a lot of the cases, well, that all of us here are kind of these new issues. It kind of goes to the earlier question about younger generation too, right? And so at the end of the day, you have to use your judgment. And that's based on things that aren't necessarily kind of written down, right? Your life experience, what you've seen before, conversations you've had with other people. I mean, all of that, the values you bring, to the job, all of that goes into the decisions we make on those close cases as well. So it's, the law, I mean, sometimes I think people think of the law as like this logic puzzle that you can just solve. And it's really not like that at all. It's more of a, you're kind of weighing things out. And at the end of the day, it's what your gut and your head tells you and your heart, I suppose, as much as anything else.
Thank you.
Hello there, y'all. Cool. Hi, I go by Percy. First, I was curious how y'all were doing today. Good. Awesome. So my question is close to what Benjamin was kind of asking. I was curious because it takes a long time to become a judge, and by then it's kind of hard to be considered young by the time you get to be. I'm kidding. I'm gonna watch my step here. Well, I mean, how can someone my age get involved in the government or in the judicial branch or any of that kind of thing?
Excellent question. So what grade are you in school?
I'm a senior.
Senior. All right. So are you looking at colleges?
I've decided.
Good. Then get yourself involved at the college level in organizations that, are looking at things that could be relevant to government, to the court. If you're interested in becoming a lawyer, and I just would put a shout out to everybody out here that's got an interest in the law needs good lawyers. We need people who care. We need people who are passionate about a cause, but want to go to work in the system. And so, to get to law school, you got to go through a 4-year degree, as Justice Hudson said, and then you go to law school. But there's a lot of opportunities now for legal education that could put you in a position to, be up here on stage someday arguing to a court.
Sure. Thank you and have a good day.
You too, Percy.
Hi. I just want to say this before I ask my question. I salute y'all for sitting for long periods of time, just sitting. Because personally, me, I got a bad back, so can never.
I feel you.
So, okay. So my question is, why? Why did y'all want to why did y'all want to become like lawyers or judges or something? Was it your parents and said oh, this is what I want you to be, or
So the question goes to, how do we wind up being lawyers? How do we wind up being judges? Some of this is your life experience. I'm sure there are people who've become lawyers and judges who didn't really think about it. Others of us, I had a mentor, a relative who's a lawyer, and that seemed to me to be an honorable and responsible way to contribute to society. And I'm not sure how I connect with the younger generation. Friends of mine would say I was old, young, and that's there's probably some truth to that. But in my case, it was a natural fit. I was a high school and collegiate debater. I had an interest in legal issues. It led naturally to law school. I don't know that I had any real thought about being a judge. That came much later, after 20 years of practice. Our model's a little different than some countries, because in some countries you leave college or law school on a track to become a judge or a track to become a lawyer. I like our model. I'm biased in favor of it because I think you bring a whole set of, everybody up here has had different experiences as a lawyer, and it informs the work that we do. So that's my route for whatever it's worth.
Slay.
Go ahead.
Hi, my name's Hunter. My question was more so just about our country. What qualifications or expertise do you believe Kanye West has to being a viable candidate to the United States presidency?
So I think that's the kind of question that we probably aren't going to weigh in on. So I'll just leave it at that.
Sounds good.
Thank you. You got your own fan club out there.
Sorry, what?
You got your own fan club out there.
Apparently.
Yeah.
My name is Devin. I'm just curious, throughout all of your guys' careers, obviously I'm assuming becoming a member of the Supreme Court in Minnesota has to be one of the high points in your careers as lawyers, judges. But I'm curious, what was one of your most personally kind of achieving or personal, not necessarily personal, but what was one of the best accomplishments that you've had before kind of becoming a Supreme Court judge?
So I'll give you a couple of examples. I was a lawyer at the University of Minnesota for 11 years, and one of the last cases I worked on for the university involved an elderly woman who passed away and left a bunch of money to the university, and some other charities. But the charities didn't get the money because there was a financial advisor who ripped her off and he got the money. And we were able to, with the help of the Attorney General's office, we were able to unwind those transactions and get the money back. That felt very gratifying for me as a professional, that I felt like we were giving voice to what that lady wanted to have happen with her estate. And then I was a prosecutor when Senator Klobuchar was the Hennepin County attorney. I was a prosecutor in her office for a while. And I worked on prosecuted cases where people preyed on vulnerable adults. So if you were supposed to be caring for grandma, instead of caring for her, you ripped her off. Those were the kinds of cases I prosecuted, and I found that personally rewarding as well as a lawyer. And I know that each of us has stories like that. Thanks for your question.
Absolutely. Thank
Go
you for your
ahead
time.
next.
I got a fan club too. From what I understand, you're not supposed to have any personal beliefs or anything when you're doing a court case, but I think that can also give you insight and differentiate you from your other judges. How do you balance that out when you're judging a case?
Yeah, that's a good question. You know, as I think one of my other colleagues said, you know, we all bring to the bench who we are. You don't divorce yourself from your background and your lived experiences. And that's a good thing on a collegial court. You wouldn't want 7 Natalie Hudsons. I mean, so I'm lovely, yes. But you know, you bring those experiences to bear on the decisions that you make. That said, you know, we come to the bench taking a vow to uphold the Constitution of the state of Minnesota, the Constitution of the United States. And there are times when you have to put aside some of your personal beliefs about a particular case. If any judge tells you that every opinion they've written, they absolutely agreed with, they would be lying to you. We all have written opinions or are signed off on opinions that we didn't personally agree with. Because I'm not Queen Natalie, and so I don't get to always do what I want to do. And so you take an allegiance to what we call stare decisis, to our precedent, to the constitutions, and you try to find a way to balance those while at the same time being true to who you are. And it's something we all struggle with day in and day out. It comes with the job. But it's what makes the law, I think, fascinating and what makes judging fascinating.
Okay, we have
Thank you.
Thank you. We have time for 2 more questions, Lissa's saying. And we'll be quick. Go ahead.
Hello, Your Honors. You all seem like very smart people, and my question was, what's one piece of advice you give to a high school student now?
Oh, wow. One piece. Well, that's one, but I think I'm going to give you life advice. I would say don't take things personally and take everything as a compliment if you can.
Thank you.
Hi, my name is Rosalia. He already kind of like talked about what I wanted to ask. For those who want to join, like, are interested in like the legal system, do you have any advice for the younger people who are interested? And
Yeah, I mean, I went to a very small high school. I mean, my graduating class was 60. But I was, you know, in student council. I was in, I don't even know if they have office education anymore. You're probably like, what's that? That's when we were typing. But anything that was, you know, sort of in leadership or trying to help people in my community. I did a lot of volunteer stuff. All of that is the makings, including working. I started working when I was 13. And I think that just being able to work and then go to school and balance all of that with sports, all of that, everything that you do is going to help you reach that goal. There isn't anything that's specific that you have to have a box to check off.
thank you.
All right, Lissa, are we done? Where is Lissa? There she is. We're done. All right, you guys have been great. Your great questions. We so appreciated our time with you, and we're done. Thank you. Thanks very much. Thanks.